Now we begin our discussion with contracts. And what to expect in this subject. We'll discuss general provisions, characteristics of contracts, the kinds of stages, essential requisites, form, interpretation of contracts, then the different kinds of defective contracts. Okay, we start with defining contract. Contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So in this definition, one is obliging himself of giving or rendering service. So almost similar to an obligation. Also, we'll define real right. Real right is a right attached to a thing such as ownership, usufruct, including its accessory rights like pledge, mortgage. So pledge is prenda in Binisaya. Mortgage is also prenda, but it involves real property. Now this right is enforceable against the whole world. So if you have such right, you can pronounce it against the whole world. So unlike a personal right, which is enforceable against certain persons only. So usufruct is a term which is used if a person has a right to use a property which is owned by another, probably by virtue of a valid agreement. No? So there's an agreement that you can use his property. Okay. Gratuitous, on the other hand, is a term to describe if it is free or given without any charge. No? Freely given by the owner to you without any charge. Now, number 5 is ratification. Ratification is to adopt or confirm any act of one person who performs in the name of another person, even if he is not benefited. No? So ratify. And then assignment is the act of making a legal transfer of a right, property of, or a liability. So another word for assignment is to transfer. So if you are being given a property, that is assignment. So there are different kinds of contracts, principal and accessory. These are the different principal contracts, contract of sale, loan, pledge, lease, tenancy, comodatum, modatum, then deposit, donation, contract to sell, contract of carriage, employment, articles of partnership and corporation. Accessory contracts, this cannot stand by itself. It requires a principal. These are warranties, mortgage, anti-crisis, contract to pay interest, surcharge, or penalty. These contracts have names designated by law, so they are nominate. There are contracts without names, and they are called innominate contracts. So what are the different characteristics of contracts? The first one is autonomy of wills. Autonomy meaning freedom, like the Muslim Mindanao, Muslims in Mindanao, they want autonomy. So autonomy of wills is that in contracts that the parties may establish stipulations or provisions or any terms or conditions that are any kind of conditions, as long as they are not contrary to law, morals, good customs, public order, or public policy. So we know what are laws, we know what are morals, good customs, public order, and Public policies, I already discussed this in obligation. In labor. Now, mutuality, on the other hand, is that the contracts must be binding between both parties. Both, no? Because there are two parties in a contract, two or more. So if it is not, if a contract is left to the will of one person, then there is no mutuality. No? Number three, obligatory force means that the contracting parties are bound from the moment they perfected the contract and fulfilling in good faith what has been expressly agreed upon. So any terms and conditions should be respected because it has a force of law. You know, it is obligatory. Then protect creditors. Contracts are, the law protects creditors in case of contracts which are intended to defraud them. Provided in Article 13 of the Civil Code. Then we have relativity. Relativity means that contracts only take effect between the parties, their assigns, so the transferees, or their heirs. No? But there are exceptions to this law. This is provided in Article 1311. Exceptions to the relativity principle is that when the contract involves intransmissible right, meaning it cannot be transferred from one person, you know, like contract to perform. If you are a singer, then you contracted that you will perform a concert. It cannot be transferred. You know, that right cannot be transferred because it is personal in nature. Number two, contracts creating real rights. These contracts, the third parties are bound by real rights. Okay, so third parties should respect what is created by a contract involving real rights. So we have discussed real rights already, which pertains to ownership of the thing. No? So if you buy a land, then other persons would respect that. They will not squat on your land or try to possess your land because you are now the owner. They will respect that. No? Number three, contracts intended to defraud creditors may be rescinded by the creditor. So a creditor is a third person. He is not a party to the contract. So if he is defrauded in that contract, then he can rescind or cancel the contract. So another exception, tortuous interference with contractual relations. This means that a third person can interfere with a valid contract without a legal justification in case of tortuous interference. Another one in contracts with stipulation por utrui. What is this one? A third party can claim benefits under this contract because the parties in the contract clearly and deliberately conferred a benefit to him, and this third party accepted the stipulation por utrui. So, for instance, I will sell my land to Mr. X, and we agreed that 50% of the payment should be given to my son, you know, who is in the U.S. And he agreed to pay 50% of the amount to my son. So, and then my son should accept it. So that is stipulation por utrui. Now there are requisites for stipulation por utrui, and this are the following. Okay, number one, that the parties must clearly deliberate and clearly confer upon a favor or a favor upon a third person. So it should be stated in the contract. Then the stipulation in favor of third person should be part of and not the whole part. So as I have given an example, only 50% of the selling price or the price of the consideration of the purchase price should be given to my son. Number three, that the favorable stipulation should not be conditioned or compensated by any kind of obligation whatsoever. So there is no condition that subjected the giving of the 50%. There's no condition. Then number four, neither of the contracting parties bears the legal representation or authorization of third party. So there is no third party being authorized or represented. It should be me and the seller, no SPA involved, okay, or special power of attorney. Also the third party, no SPA. And the last one, the third person communicates his acceptance before revocation by the original parties. So already stated that my son should accept the 50% payment. So there are different kinds of contracts according to perfection. So perfection is a stage of contract where the parties already agree or would already are bound by the contract. They are bound by the contract. And number one is consensual contracts, like a contract of sale. No, a consensual contract is perfected by mere agreement of the parties without any formal requirement. So without any written, only by verbal, there's already a contract. Say, for example, you want to ride a taxi and you want to go to SMC side. Then the driver says, okay, I will drive you to SMC side. So there is already a contract which is consensual, no written form. Also, a contract of sale is consensual in nature. Does not require written form, but there are some exceptions. Then the next one is real. Real contracts are those perfected by delivery of the object. So it cannot be perfected by agreement. It should be. It can be perfected only when the thing is delivered. Example of real contracts are comodatum, pledge, or deposit. So comodatum is when you borrow a thing gratuitously, meaning you borrow a thing without payment, free. So if you borrow a book from the library, that's comodatum. You cannot borrow a thing, you cannot borrow the book without getting the book. So the contract is perfected by getting the book. So it is perfected by delivery. Also pledge. Pledge is sangla or pawning, go to the pawn shop, no? Involving a personal property. Now this is a contract of loan, but there is a guarantee, which is pledge, no? Actually, pledge is it's a secondary contract, the pledge. But the main thing is contract of loan. So this is an accessory contract. So if you contracted a loan, you borrow money, but the pawn shop wants you to give him a guarantee. So what is your guarantee? Say I have this eyeglass. This is Versace, very expensive. So if he takes it, that is your security, and the security now must be delivered to the pawn shop. So there's delivery. You cannot get the money unless you deliver the thing to the pawn shop. Okay, that is real contract. So deposit also, this is practiced in the malls. When you enter the mall, before you enter the mall, you are required to, when you're bringing something like a knapsack or bag, then the security guard will will require you to leave your bags behind. So that is deposit, no? Also gratuitous without any payment. So this is a contract of deposit purposely for security and safety. Okay. Now formal contracts, this requires essential formalities like a written contract. Example here is donation. So if your father would donate a piece of land to you or more than 3,000 pesos, it cannot be, or more than personal property more than 3,000 pesos, it cannot be perfected without a written form. No, there should be a document signed by your father. So otherwise, that donation from by your father would be void. So wala effect, no legal effect. So once your father would give you a piece of land, imoaning yuta, require him to write that donation in a piece of paper, and then you have to accept it. No? So you will accept his donation in the document, and you go to a notary public. Okay. And there are contracts also classified in accordance with cost. So cost is the third requisite of a contract, uh, like a consideration, no? Like payment. So cost here with valuable consideration, so onerous. So onerous, if you buy something, if you buy a car, you have to pay. So there is valuable consideration that is onerous. Okay. Gratuitous, if it is founded on liberality or generosity, like comodato. So there's no payment involved. You borrow a book from the library, that's gratuitous. Donation, that is gratuitous without any payment. Remunerative, on the other hand, the prestation here or the subject matter is the service that is being rendered as that is being rendered by the other party. So remunerative means it is an employment, like employment contracts. They are remunerative contracts. Then we have accordance to importance or dependence of one another. So principal contracts, this can stand by itself. Accessory, it depends upon another contract for its existence, so it cannot exist on its own. Then preparatory, not an end by itself, but a means through which future contracts may be made. Say, for example, articles of partnership. Now you agree among yourselves to make a partnership, to have a business. So that is the first contract that you will sign. And after which, you will engage in a business. So engaging in business, there would be so many contracts that you will sign with your clients or customers. So it is a contract or articles of partnership is preparatory, is a preparatory contract. Also, a contract are classified in accordance to parties obliged. These are unilateral contracts and bilateral contracts. No? In unilateral contracts, only one person or one party has the obligation, while in bilateral or bilateral, both parties have reciprocal prestations, or they are required to perform. So unilateral, like a uh, contract of comodato. So only the lender is obliged to deliver the thing, no? Or contract of donation, no? A contract of donation, only the donor, the one who gives the thing, is required to deliver the thing and has to sign the paper. So the donee, on the other hand, has nothing to do except signing the document. So that is unilateral. Now, on the other hand, bilateral or bilateral, no, both parties are required to perform like contract of sale. So the buyer will give his payment while the seller will deliver the object to the buyer. So that's bilateral. So there are different stages in a contract. First stage is preparation or negotiation. So this is where when the buyer and the seller, or let's say a contract of sale, this is when the seller and the buyer will negotiate for the price. No, okay. So the seller will say, "I have property here. I'm offering it to you for only 1,000 pesos per square meter, very cheap." And then the buyer would say, "Oh, I'm not interested, but I will buy that for 800 pesos per square meter." So that is negotiation. Okay. So they're haggling for the price. And number two stage, perfection of birth, comes when both the parties, the buyer and the seller, would agree. And then in that example, say the seller would say, "Okay, you want 800, how about 850?" And then the buyer will agree, "Okay, 850, we'll buy that." So when that comes, that is already perfection. No? Then consummation or performance is the stage where the parties in a contract delivers to one another their respective obligations. So for the part of the seller, he will deliver the object, but since it's a real property, delivery would involve only the title and the deed of sale. On the part of the buyer, he will deliver the payment or money. So that is consummation stage. Now, there are contracts which have no names, and these are called innominate. Now, for contracts with names, they are nominate contracts. So we will discuss the contracts without names. And there are four in the book, namely, do ut des, do ut facias, facio ut des, facio ut facias. So the first one is, I will give you and you will give me a thing. No? So the second is, I give you and that so you may give also. Or you may do. I'll give you this, then you do. Then facio ut des, I'll do this and you give. Number three is fascia. Number four is fascia fascias. I will do this, and you will do this. So these are innominate contracts. But the first one, do ut des, which means I'll give you this and you give me that. Okay. Let's say I have a cell phone. I'll give you my cell phone, which is an iPhone 10, and you give me your laptop, which is also an Apple MacBook. So this is giving of things. This is no longer innominate because there is already a law on barter. This is what you call barter. So number one is no longer innominate because there's a special name designated by law, which is barter. So this is already barter. The second is still innominate. I will give you my iPhone 10, provided you will paint my car. Okay. So that is do it fascias. That's an example. Example of fascio des. I will paint your car if you will give me your MacBook. Okay, that's an example of this one. I'll do that you may give. And then fascio fascias, I will do that you may do. So I will paint your car provided that you will bake me a cake on my wedding party. So that's an example, no? Fascio fascias.